All right, so we're going to go ahead and get started so that we can make the most of the time that we have with our panelists. I want to welcome all of you to the Small Business Benefits and the CARES Act free webinar being presented by the Greater Charlotte Apartment Association today. We have some amazing panelists with us this morning. I'm Sam Gilbert with the National Apartment Association's public policy team, and one of our local members who's with real estate law firm Brownlee, Whitlow, and Prate, Norm Prate. I just want to let you all know that the GCAA is the largest, one of the largest apartment associations in the country. We serve 11 counties, including Mecklenburg County and York County, South Carolina. If you're joining us today and you're not a member of an apartment association, I encourage you to get involved and get connected. There are 7 local affiliates in North Carolina, as well as the Apartment Association of North Carolina, which is the state affiliate. We have 165,000 plus apartment units represented in the Greater Charlotte Apartment Association. That's 800 plus apartment communities, and we are happy to serve your needs. This webinar is being recorded, so all of you are muted, but you can certainly send your questions and your comments through the chat and the Q&A function. We're going to go about 30 minutes for the presentation, and then at the end of the presentation, we'll allow the questions to be answered. If we can't answer the question during the webinar, we'll compile those questions and we'll put the questions and answers out to our members, and we'll make the webinar available on each of the local affiliate websites. So with that, I'm going to turn things over to Sam Gilbert and Norm Prate to get us started. Give me 1 second to unmute you, Sam.
Great. Thank you, Kim. And thanks for having us. And thank you for GCAA for having all of us come here to speak. Again, I'm Sam Gilbert with the Government Affairs team at National Apartment Association. And I appreciate y'all being here. Working with Norm Prate as well. We've received a number of questions from our members on the CARES Act, specifically on the Paycheck Protection Program, the provision that's been established as the business loan program under the Act. So we thought that this would be a good opportunity as well to give a little update and overview of that program, of the Triple P, for your benefit, as well as take any of your questions as to, how does this apply to you? So I'm going to share my screen real briefly and pop up my PowerPoint. Okay. So everyone can see? Perfect. All right. So once again, thank you very much for joining us. Again, I'm Sam. With me is Norm. And we're going to give you a little bit of an overview of the Paycheck Protection Program as established by the CARES Act on March 27th. So a little bit of background on the CARES Act. The bill was signed into law on March 27th. It was a giant omnibus bill that was considered phase 3 of the congressional response towards assisting businesses and workers and the United States with the financial hardships that were, brought on by the coronavirus. One such provision of the CARES Act was the Paycheck Protection Program. This is a $349 billion allocation of funds to the Small Business Administration's 7A loan program. The 7A loan program is the SBA's standard, most general loan program that they administer. So the $349 billion that the SBA would be backing 100% would be administered under that program, the Paycheck Protection Program. One of the big questions that all of our members have are who is eligible for this type of program? Well, first and foremost, this program is open to and the types of entities that are most eligible for this program are small business concerns. Now, what is a small business concern? Small businesses are defined by the SBA size standards metric. So that is a table which the SBA has put out that defines small businesses based on one of two characteristics. That can either be your employee size or your annual revenue. For the purposes of the Paycheck Protection Program, any small business concern, any business concern, any nonprofit, any veteran organization or tribal business with fewer than 500 employees is eligible to participate in this Paycheck Protection Program. Employees are defined as full-time or part-time. Sole proprietors, independent contractors, self-employed individuals, they are also eligible to apply for this Paycheck Protection Program as well. Certain industries are allowed a higher employee threshold according to the language of the law. For the purpose of the Paycheck Protection Program, though, 500 or fewer employees is key. As I mentioned, certain industries are allowed a higher employee threshold. So when you look at the SBA's, the Small Business Administration's size standards table, some industries do have higher employee allowance. For the purposes of this bill, certain those industries are allowed, more than 500 employees to be considered eligible for this business. Now, unfortunately for our industry, for the rental housing industry, for the two businesses that are under that subcategory within the SBA's size standards table, we're defined by revenue as opposed to employee size. So for owners of rental housing, to be considered a small business, you are allowed a maximum of $30 million in gross receipts annually. For rental property management firms, you are allowed a maximum of $8 million in gross receipts annually. However, and this is the one caveat that I'll be discussing later, is that in this bill, those industries with revenue caps must have fewer than 500 employees. And if you are a property management firm that has more than 500 employees, and even if you are within the revenue cap that is set out by the SBA size standards metric, you are ineligible from applying for this type of loan because you have more than 500 employees. If you are above the revenue cap and have fewer than 500 employees, you are eligible for this loan. So it's important to remember that 500 employees really is the most important number to remember when pursuing an application for the Paycheck Protection Program. The caveat that I had mentioned with the revenue cap, we're working on at NAA solutions for phase 4, fixes that can be made to the phase 3, the CARES Act legislation. This is something we are looking at, including a revenue cap into the language that allows all small business concerns, regardless of if you are measured by employees or revenue, having both caps be included in phase 4 legislation. So that is something we are working on. So that's regarding eligibility. I'm going to move on to our next slide now. And this is talking about terms and requirements of the Paycheck Protection Program. So the loan size is determined by multiplying your average payroll costs times 2.5. So that's rolling up 12 months worth of your payroll costs, which includes salaries, wages, healthcare benefits, all benefits, payroll taxes, and I know I'm missing one more component, and multiplying that average payroll cost times 2.5. The loans are capped at $10 million. Your paycheck protection loans can be used for a multitude of circumstances, but they must be used for these circumstances. That includes payroll costs, mortgage, rent, and utility obligations that have been incurred prior to the covered period of these loans, which is February 15th, as well as any other debt that was incurred prior to the covered period. The terms of the loan, there's a 2-year repayment period. There's a 0.5 percentage point fixed rate attached onto these loans as well. The first 6 months of the loan's payment is deferred. However, interest still accrues at this time. So 6 months of payment is deferred prior to, once the loan begins. From its origination, you have a 2-year repayment period. There's no prepayment penalties for prepaying the balance of the loan or what is owed. No collateral is required. Most fees are waived. The SBA the legislation waives all upfront guarantee fees that are normally associated with SBA loans. There's no lender fees that are associated with this financing vehicle either. The SBA has a credit elsewhere provision that is waived for this type of loan. Normally, under the SBA loan programs, borrowers will have to certify or document that there is no credit available elsewhere for them to access. That requirement is waived during the application of this loan. Moving on to loan forgiveness. So one of the provisions that have been included in the Paycheck Protection Program is the opportunity for loan forgiveness. This financing vehicle was primarily established as an employee retention tool. So giving employers an alternative to, of course, letting go of their employees or furloughing employees. This tool was meant to keep employees on payroll, and the incentive for doing that was to, of course, potentially forgive the amount that loan would be used towards maintaining their employee numbers and wages. So the loan can be forgiven if it is used only to maintain employee numbers and wages, make mortgage, utility, and rent payments, and make utility and rent payments during the 8-week period after the loan is received. So when upon point of origination, once the loan is originated, the 8 following weeks, if the funds of that loan are only used for payroll costs, maintaining employee headcount and wages, mortgage, utility, and rent payments, you may see that loan amount being forgiven. Independent contractors do not count as employees for the purpose of loan forgiveness for borrowers. That is because independent contractors are also eligible for applying for paycheck protection loans. So essentially, there was no double dipping on funds. There's 2 circumstances in which a borrower will owe money on their on their loan, and the forgiveness will not be given in full. So the first circumstance is if the loan is used for anything other than payroll, rent, mortgage, and utility obligations. Now, you can apply for the loan and you can use it for other debt that was incurred prior to the covered period of February 15th. However, for loan forgiveness to apply, you can only use it for payroll, rent, mortgage, and utility obligations. The second circumstance or set of circumstances in which you will owe money is if your employee headcount and your wages, your wages are reduced during the covered period of that loan, during that 8-week period in which you have that loan. So with headcount, it is, if you lose any employees during that time, and with wages, if you must reduce your employee wages any more than 25% of what that employee is making at the time of their hire, and if they're making less than $100,000, if you see that reduction of more than 25% in their salary or their wages, you will owe money on that loan proportional to that reduction. And there is an algorithm that is a little too complex for my own for me to be able to spell out here, but we can definitely get that algorithm out there if participants are curious. Forgiveness will be applied to businesses that are able to boost their staffing and salary levels back up to levels that were before any changes were made in those staffing levels between February 15th and April 26th. So if there were, if employees had to be let go between February 15th and April 26th because of, COVID-19 related impact, if you can rehire employees and get them up to the salary levels that they were at prior to their departure, you are still eligible for the forgiveness provision of this loan. Now, employers must request forgiveness through their lender, and lenders, and they must certify that they've rehired their employees that were let go between that February 15th and April 26th period. They must certify that the wages have been raised back up to the original levels. Lenders must give forgiveness within 60 days of receiving that request for forgiveness. Moving on to payroll protection programs, important dates. These are just important dates for everyone to remember regarding each specific provision. So for application deadlines, or openings, I should say, deadlines might not be the best word. Applications have opened. They first opened today, April 3rd, for all businesses and sole proprietors. I believe the SBA and the Treasury Department wanted to make sure that businesses were the first to kind of get the opportunity to submit applications for these loans. April 10th, next week, is when the applications will open up for independent contractors and self-employed individuals. On June 30th, the program closes. Applications will stop being accepted. For loan payments, again, it is a 2-year repayment period on these loans. This is different than, which I'll be speaking about this type of loan just a little bit, but this is different than the disaster loans, the economic injury disaster loan that the SBA puts out, which is I believe a 30-year repayment period. For the Paycheck Protection Program loan, again, this is at a 0.5 percentage point fixed rate. The first 6 months of your payment is deferred. Interest is still accruing during that time, However, the first 6 months of payment are deferred. On loan usage, loans can be used for interest on mortgage obligations that's incurred prior to February 15th, as is rent for lease agreements that have been enforced before February 15th. Again, this February 15th is the start date of the covered period. So any debt that has been incurred prior to the start of that covered period is what the loan can be used for. Finally, with loan forgiveness, the 8-week period from loan origination to due date, that's the important period of time to remember in terms of what can be forgiven and what so you need to use the loan specifically for maintaining employee headcount and wages, rent, utility, and mortgage payments during that 8-week period from the loan origination to the due date to be eligible for loan forgiveness. June 30th is the final date in which employers can rehire employees to their full staffing and salary levels to be considered eligible as well for restoring to normal staffing and salary levels. June 30th is that final date. And then, as I mentioned, lenders must render a decision on forgiveness within 60 days of application of receipt. So those are the important dates to remember, the important periods of time to remember as well. As I mentioned, there are some caveats. First and foremost, the size standard. This is, as I mentioned, small businesses, and as a rental housing industry, we're defined by revenue, not employee size, to be considered a small business. So again, for all of our members who may have more than 500 employees but fit within the revenue standard of small businesses as determined by the SBA, you would not be eligible for this loan. If you are under 500 employees, as I mentioned, fewer than 500 employees is the most important number for our industry. If you are under 500 employees, you may be eligible for this loan. Loan forgiveness. Sole proprietors are precluded from the loan forgiveness provision of this law if the loan is used to protect your own salary. So for sole proprietors of properties who may not have other employees, who may be independent operators, operating independently on their own, that loan forgiveness provision cannot be applied to your own salary that you generate. For physical location, one of the big questions we've been getting from members is, I have more than 500 employees, but I have fewer than 500 employees spread out across multiple physical locations. Under this law, those types of companies are not eligible to receive funds. There is a provision that allows companies with more than 500 employees across more than one physical location with fewer than 500 employees at each location. There is a provision that allows them to be eligible. However, it is only for two industries. That's the short-term accommodation industry as well as food services industry. So that's another thing that we're looking at in Phase 4 legislation and a fix is getting residential and building services into that more than one physical location caveat, that provision, because it really does, it can apply to our industry. And then finally, commingling of funds. So I'll just speak briefly about the disaster loan program that the SBA offers. Borrowers of the Paycheck Protection Program loans, they're prohibited from receiving economic injury disaster loans. This is essentially to prevent double dipping of SBA funds. The economic injury disaster loans, part of the SBA's disaster loan program, These are loans that are available to any small business concern as defined by the SBA's size metrics. So revenue caps, so our industry, members of our industry and businesses within our industry that fit within that revenue cap now, regardless of 500 employees or not, are eligible for the economic injury disaster loan if you meet the small business definition by way of revenue cap in that metric that the SBA puts out. This is different from the Paycheck Protection Loan in the sense that the fewer than 500 employees does not apply for disaster loans. However, with disaster loans, it's a maximum of $2 million. That's what the loan size can be. It's a 3.75 interest rate, and I believe the repayment period is over 30 years. These loans are available through a presidential declaration of disaster in a state, and then they are available statewide. So as of, today, every state is eligible because every state has received a presidential declaration of disaster. So businesses across every state can apply for these economic injury disaster loans, which basically go towards, again, meeting routine financial obligations of businesses. But again, you cannot commingle the funds. So Paycheck Protection Program borrowers may not receive the economic injury disaster loans. So these are some important links that participants here may find useful and businesses may find useful. First is the SBA guidance fact sheet. Now this is a pretty intro level fact sheet about the program, who is eligible. Does not necessarily go into specifics into kind of the types of questions that I've received so far from our members because those questions have been so specific. There is also an additional interim final rule that I do not have listed on here that came out this morning. I will make sure that I can get that link to Kim for distribution to all the participants here and everyone else at GCAA. There's a sample loan application, which I also believe has just been updated this morning too, given that the applications for businesses and sole proprietors opens up today. There is a new sample loan application that's also available. Economic injury disaster loan FAQ, important if you realize that your business needs are more aligned with the benefits of a EIDL as opposed to the Paycheck Protection Loan Program. And then finally, I have a link for the office locator for SBA regional and district offices. I don't think you can find any better guidance than speaking to the SBA directly, as well as speaking to your lender, speaking to an SBA approved lender. They're really going to be the most important resource that you can find on this topic. At this point, I'm going to open it up to questions, but before I do that, I just want to throw it over to Norm for a few moments in case, Norm, if you have any further comments or anything you would like to add in addition.
Okay. Am I on now?
Yep.
Okay, thank you. As Sam said, this is all information's coming out day by day now, and this last guidance that came out either early this morning, late last night, it refers that there'll be other guidances, especially including how the loan forgiveness is actually going to work out. Just had a couple points in your application. If anybody received the $10,000 emergency loan from the SBA, that can be refinanced here. So whatever your payroll number that the second guidance now that came out today has a more detailed explanation of how to figure out your monthly payroll that's included for the 2.5 times multiplier for your application. But on top of that, you can add the $10,000 SBA loan, emergency loan, if you've received that. So that increases the amount of funds there. These guidances still are being rushed and not completely clear. When you're putting together your payroll numbers, the most difficult and probably the most important portion of the loan application is figuring out what that payroll number is. They've got a sort of detailed breakdown in this guidance, and Sam said he'll include the link for you all at the conclusion. But it goes through figuring out your payroll, reducing the effective rate of compensation to any high-paid employees to a maximum of $100,000, and that includes health benefits and everything like that. What it doesn't really show well on this guidance, but it sort of answers later on, is you should deduct any FICA and federal taxes in your payroll before figuring out the full amount. And we've done the calculations and looked to see how this would all work, and that can make a significant difference in all of it. Let's see. And just in terms of Sam had brought up the revenue cap a few different times. For anybody who's not familiar, the Small Business Administration has a whole document for all the industries and things like that as to what it considers small business, and in some places it talks about the number of employees, and in some places it talks about the revenue. So that's what the NAA is working on. It's, as he said, $8 million, I believe, for managed residential real property. So that would help certain people if we did that rather than the 500 employees. And going through this new guidance also, the biggest question I think Sam touched on also that we've been hearing and that we know NAA has been hearing is, can the owners of the property include the employees of the management company in making an application to the SBA? And the answer seems to be at this point, even more clearly from the newer guidance, no. It's got to be the management and company that includes their own employees on the payroll. The owners of the property may be reimbursing the management company for all payroll costs, but the employees are on the management company's payroll, not the owner's payroll for this. Again, and that's something that NAA is looking for further clarification. We don't expect, based on what I've heard so far, that there will be a clarification coming out within another, a new version of the CARES Act, the next stimulus probably won't be out for a couple weeks. And depending on how many lenders start opening up their doors to process these applications, this first round of funding could be gone by then. There very well may be second round of funding in the next bill. We don't know. I know a lot of lenders are kind of on pause right now, trying to figure out, especially with the newest guidance, what their exposure is. Because the way this all works is the business owner fills out the SBA application and submits certain supporting documents having to do with payroll only, because there shouldn't be any other underwriting necessary because there's no guarantees at all. But they submit this to a bank, probably the bank they work with most of all, because all the banks are going to be inundated with applications here. And from what I'm understanding and speaking with several, they're all giving preference to their regular clients, their regular people who bank with them before processing anybody who they don't have a relationship with. And then the SBA goes through, then the bank goes through before submitting it to the SBA and checks to make sure that the amount that the borrower is seeking is correct under the act. And if they don't do that properly, they feel that there's some liability to them. So they're trying to figure all that out now. So that's basically the few points I wanted to hit on before we start answering questions. Unless Sam wants to fill in anything there.
No, I've just begun looking at the questions as well, and there's already a few that that we can kind of answer right off the bat. If we want to be able, Kim, if we can just jump right into the Q&A.
Go right ahead. Yeah, absolutely.
Perfect.
Sounds good.
So I know the first one that we can look at right now is Cindy Rankin asked, can one do both the PPP and the EIDL, that's the Economic Injury Disaster Loan, if the EIDL is not used for the payroll? The answer to that question is if your economic, and this is according to the interim final rule that was just put out this morning, if your EIDL loan was not used for payroll costs, it does not affect your eligibility for a Paycheck Protection Program loan. If the Economic Injury Disaster Loan was or is used for payroll costs, your Paycheck Protection Program loan must be used to refinance that emergency economic injury disaster loan. So what I believe that would mean is, again, if it's not used for the same purpose, you couldn't use both loans to satisfy the payroll cost obligations of your company.
And for ultimate forgiveness, you want to make sure that you're using at least 75% of the payroll protection program loan for payroll. I don't know that it was exactly clear in the act, but that's how the SBA has interpreted it and decided it was within their power, that the main reason it's called the Paycheck Protection Program, they want at least 3/4 of the funds to go to keeping employees in place. So they want to see that go to payroll. Then you've got 25% that can be used for the other enumerated things like rent, utilities, things like that. Anything else, you may still be entitled to the loan, but there might be, if there's money that goes to other things beyond those, you'll likely have to pay those funds back, and they won't be forgiven. But you have 2 years to do it with a 6-month non-payment window, and the rate is looks like it's 1% now from this new guidance. Before, what we saw was 1/2 of 1%, but this new guidance going out today identifies it as 1%. So that's continuing to evolve.
All right, so Cindy, thank you for that question. Colin asked, so if a property management firm above the 8 million in gross receipts annually, but has less than 500 employees, is this entity eligible for the for the Paycheck Protection Program? Through our analysis of this bill, we've kind of reached the conclusion that any entity that has fewer than 500 employees is eligible for this. So even if they exceed the small business definition, the revenue cap that is within the SBA's size standards, any business concern is eligible for this loan. So if you exceed that revenue cap, but you are fewer than 500 employees, you are still eligible. Right now, the language in the bill only says that companies that exceed 500 employees but meet the applicable employee size standard from the SBA are eligible. So yes, to answer your question, fewer than 500 employees, exceed the gross receipts, you should be eligible for the Paycheck Protection Program. If you are an LLC and you are the only employee of that LLC, does the single employee apply as the LLC paying the employee or as the employee out of work? If you are LLC and you are the only employee of that LLC.
With that, one thing to note is you can apply for both unemployment and to protect your paycheck at the same time. So I believe you could, if you're not seeking unemployment, you could use these funds towards your payroll if you're a sole proprietor.
Okay, perfect. Norm, thank you. Do businesses apply twice for the PPP? Once on April 3rd for their staff, and then once on April 10th for their owner's salary and independent contractors?
No. Businesses can't apply for their independent contractors at all. They thought, and that's clear in the second guidance that just came out, that independent contractors can apply on their own behalf, and that's the April 10th filing, and business owners are included in the April 3rd supply as long as they're not a sole proprietorship. So you're implying if you're an owner of a business and you've got a staff of 10, you just put all 11 of you in the calculations for the April 3rd filing.
And one other important caveat is that the salary forgiveness, the loan forgiveness does not apply for any employee whose salary exceeds $100,000.
Well, it applies to the employee, it just doesn't apply to the amount in excess of $100,000.
In excess of 100, yes. Apologies. If the funds are used only for rent and utilities, does that matter, or is it any combination of the allowed expenses? I think this is obviously in reference to the loan forgiveness. If the funds are only used for rent and utilities, does that matter? I would say that rent and utilities for loan forgiveness, they are part of the requirements for achieving loan forgiveness. If you have a staff as well, you need to make sure that your staff levels are brought back up to the levels they were at prior to the covered period. So if there were any changes that were made between February 15th and April 26th to headcount and salary and wage level, you need to get those numbers back up to where they were prior to the cover period, or else you will see a reduction in the forgivable amount. So while the loan is available for rent and utilities, if you have a staff, you also need to make sure that your you also need to make sure that the head count and the wages and salary levels are back up to the levels that they were at prior to the covered period.
And again, they want to see 75% go to payroll. So it can't be only used for rent and utilities. You're going to have a problem with a large portion of the loan then.
Cindy Rankin asked, do you know if churches are eligible? Actually, I was watching Secretary of the Treasury Steve Mnuchin was speaking last night, and I believe he did say that there were faith-based organizations that were eligible for this program. I don't really know the details of what their requirements are, but I believe those are eligible. For apartment complex owners that employ third-party managers, can the payroll costs for those properties be used for the Paycheck Protection Program loan? Our property manager is not including payroll costs from our property in their own PPP loan application.
I think that's the question that everybody's asking, and
you're right.
We don't think the complex owners can use the employees. It's based on everything we've seen so far. It looks like it's got to be through the property management firm.
What is the difference between the PPP and the economic injury disaster loan? Terms, loan size, how the loan is actually generated, or how the loan is obtained. Economic injury disaster loans, they are disaster loans. It's a separate program from the Paycheck Protection Loan, which is under the SBA's 7A loan program. So with the PPP, it's a cap of 10 million, or 2.5 times your average payroll costs. With the economic injury disaster loan, that's a cap of 2 million. Interest rate is higher on the EIDL loans. As well, I did see there was a question on interest rates for the PPP, and yes, those, and actually my mistake, those interest rates have bumped up to 1% on the Paycheck Protection Loan as of last night. The Treasury has bumped up those interest rates as well to 1%. They've doubled the interest rate on that loan. I don't believe that there is any change in the deferment of payment, the 6 months of deferred payment as well. So that I believe still holds. But yes, and I just saw that as well, that that interest rate has bumped up to 1%.
It's an exciting program that keeps changing before it comes out.
Yeah. Karen asked if this is an S-Corp, is the owner's payroll included in that figure?
Yes, the short answer is yes. That kind of goes back to the other one we looked at. They have to file on a different day. The owner's salary is included, and it's total compensation and up to 100,000. So it's deducting any other forms of compensation and healthcare and things like that to reach that $100,000 maximum number.
Will only employees laid off after loan origination count against forgiveness? Example, if I lay off someone already in March before receiving a PPP loan, will that count against forgiveness? So it does have to occur during the covered period. Any staffing changes that occurred between February 15th and April 26th, that is when if there are any changes to staffing levels or employee wages or salaries between that period of time, February 15th to April 26th, you will count any staff that was let go or left at that period. You want to get during that 8-week period that you have the loan from origination to due date. That's when you want to use the funds to get staff levels back up to what they were before the February 15th, the start of the covered period. So hopefully that answers that question.
Then Paul asks, some have said the money will run out quickly, yet many banks seem unable to process now. Please comment. Yep, that's the reality we're in. So hopefully there's enough that aren't comfortable processing it, and that's slowing down the roll a little bit of these funds going out. I was texting with one of the banks we work with regularly, and they said they've only heard of a couple people moving forward with the loans, and they've heard of a lot of them holding back and trying to figure this out, particularly as the information, a lot having to do with it didn't come out till late last night, early this morning. But that is the situation. There's not a whole lot more to say about it. So just try and keep pressure on your lenders, banks that you deal with, to move forward as quickly as possible.
Looks like the next question is, you can include up to 100,000 per employee. Does that include benefits? So can you claim added health benefits? For payroll costs, your employee benefits, so health benefits, are included in the payroll costs. So that will come into the calculation of your average payroll costs, your health benefits as well. How will the loan funds be tracked?
That gets into the forgiveness, and there's still the SBA in this guidance that just came out said they'll be giving more and providing more information on that in the future. But you'll have to submit your payroll records, I'm sure, to your lenders when applying for the forgiveness to show how the funds were used, as well as rent or whatever else whatever allowable funds that you've used towards the forgiveness application. There's no way to say you get $200,000 wired into your account from the SBA. There's no way to know how that was used, as opposed to the other $200,000 or $5,000 or whatever was in your account at the time. You'll just have to show that the certain amounts were used towards payroll and towards rent, and you'll get credit. You should get credit for forgiveness for them. That's the way the program seems to be lining up in the intent of the program.
And then finally, Colin asks, would you explain the main differences between the economic injury disaster loan and the PPP and how to determine which one is best for me? Ultimately, it comes down to what are your business needs. Main difference is that the Paycheck Protection Program has this loan forgiveness provision. The economic injury disaster loan, while it has a longer repayment period of 30 years, it doesn't have that forgiveness provision. And it's not really used as an employee retention tool. I mean, yes, it can be used for payroll costs, but it's more of an emergency. It's essentially an emergency loan. It's used for more shorter term financial obligations that you have to meet. I think the purpose of the PPP was really to retain employees for this 2-month period of time. And it obviously, it has the size of the loan can be a lot greater for a Paycheck Protection Program based on your payroll costs.
Yeah, but the EIDL can be used for any legitimate business purposes for the most part, where the PPP is very limited. So it would depend on what you need the funds for and how much or what amount of funds you think you need. But obviously the forgiveness of the PPP is very attractive in that it's more of a grant than a loan in terms that the forgiveness you do not have to pay back. Sorry, Kim.
No, that's okay. We have one other question from Cindy Rankin. Can a 1099 sole proprietor use for mortgage rent for their home, the PPP?
Probably to the extent that they can deduct it in their taxes, I would guess. That's kind of a high level tax question, but I'm guessing that it would work the same way. Sam, do you have any other thoughts?
I recognize that the sole proprietors are eligible for these funds. Yeah, beyond kind of Norm's response, I don't think I would be able to give too much more for that one. Cindy just asked another question: is the 10K advance forgiven? I believe so. I believe
it can be financed into this loan, so
yeah.
it appears that way. We're still looking at this new guidance that came out, but it appears that it should be forgiven. It probably will need to be used for one of the purposes of the loan, but to the extent it went to payroll, ideally, or possibly to rent, depending on where you are in your percentages and everything, it should be forgiven.
And again, that $10,000 advance that comes with the IDL, that can be, at least in the bill, in the law, it is written that you can receive that up to 3 days after application for it, alongside your EIDL application.
So I think that gets us through all of our Q&A. I think we had some chat, but I think we caught the questions in the chat as well. I do want to make sure that we caught the one from Colin. Would you explain main differences between EIDL and PPP and how to determine which one is best for you? Did you all tackle that one as well?
Yes, that was one of the last ones.
Okay, great. And so with that, I'm going to thank Norm and Sam for joining us today for presenting this topic. It is timely, as today is the first day that these loan applications can be filed with SBA lenders. We will make the recording of this webinar available on the Greater Charlotte Apartment Association's website to our members, and we will be sharing it with our other affiliates in North Carolina. Again, if you're on the call and you're not a member of the GCAA or another apartment association affiliate in North Carolina, I encourage you to visit their websites and join. Thanks everyone, and have a great day. Stay safe and shelter in place.
Thank you for having us, Kim.
Thank you.